Good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Billy Autry. Billy Ray Autry.
Judge, last I spoke to Mr. Archer, he was in custody, and I have looked right now to see that I have any contact information for him.
Thank you, sir. Douglas English. Alfonso Perez. Mr. Perez here. Okay. Ryan Mason. Carlos Padron. Jasmine Perez. Shakol Sampson. Shakol Moni Sampson. Michael Ringgold. All right, those are the only cases that are set for 9. We have one set at 9:30 and one set at 11. Mr. Molina Hernandez, I'll recall that at 9:30. We have any counsel that's ready?
Judge, I believe I'm ready.
Mr. Perez, if you'll come forward, this is cause number CR 23-67. Mr. Perez is set today on the state's motion to adjudicate. Go ahead, Mr. Manning.
Judge, communication from the state yesterday regarding the sort case. We'd like to have it reset to continue our work on this case. We said the dead and tested evidence.
Any objections from the state?
No, no.
All right, court will set Mr. Perez for a final docket or final hearing on the motion to adjudicate Thursday, October 2nd. Once he signs his appearance, he's free to go. Yes. ready, Mr. Ringgold?
Yes, sir.
This is cause number CR 20-356, State of Texas versus Michael Thomas Ringgold. Hearing on the state's motion to adjudicate. Go ahead, Mr. White.
Your Honor, the state and I have come to an agreement whereby Mr. Ringo is going to be on that in the ISP program. And he is going to report. He'd been reporting in Wood County. Ms. Ventura wanted him to report here, and the state is going to withdraw the motion.
State.
That's correct, Your Honor. We had made arrangements. We were also in contact with Ms. Matura about that, and she was in agreement.
All right, so are you filing that today or?
And I wasn't sure how the court wanted the state to proceed, whether we need new paperwork, just reflecting that change in condition, because my understanding is that he was already on ISP. It's just a matter of him now reporting in Van Zandt County rather than, I think it may have been Hunt County, Wood County, pardon me. So that's really the only change.
But is there a motion filed, motion to adjudicate file?
There was, it would be just.
Then you'll need to withdraw that motion. Otherwise that would remain pending. So
Okay.
it'd be a motion to withdraw and amend. Maybe you don't even have to amend if it's just a matter of redirecting. But if his conditions say that he's to report in Hunt County, then you'll need to withdraw and amend.
Yes, sir.
Yes, sir. We'll get right on that then.
Okay. All right. So Mr. Ringgold, just stick around, let probation get the paperwork done. You'll sign that and then you'll be free to go. That's right.
Your Honor, that's all I have.
Thank you, Mr. White.
Thank you, Judge.
Mr. Schmidt, are you ready?
Ryan Mason.
Mr. Mason, if you'll come forward. This is cause number CR 22-70, State of Texas versus Brian Douglas Mason, set today on the state's motion to adjudicate.
Judge, I would ask, excuse me, to set Mr. Mason for a plea on your next docket at 1:30. Or your next contested documents.
Is it gonna, it's an agreement or is it tested? Agreement? The next contest is not gonna be till October, so I'd rather not set
So
it.
that's what I'm looking for. Mr. Mason has some business that he has to wrap up. That'll run concurrently with these matters. So that'll give him time to tend to that, and be ready to rock and roll.
The objection from the state.
No objection, Your Honor.
I don't want to do the second because that's an evidentiary day. So what about the 14th, October 14th?
Yes, sir.
All right, court sets Mr. Mason to enter his plea before the court October 14th,
1:30, Judge.
1:30.
So that means you're not on this thing. We'll take care of it. So. Jasmine Perez.
Ms. Perez. Clause number CR 22-247, State of Texas versus Jasmine Catherine Perez, hearing on the state's motion to adjudicate.
That's correct, Judge. We have an agreement. We'd ask to set her off for a plea.
How long do you need, Mr. Schmidt?
I think it's, I'm gonna ask for the same thing. It's another one of those issues at 1:30. Give her an opportunity to get her affairs more.
And
no objection, Your Honor.
All right, court sets Ms. Perez then for plea before the court October 14th at 1:30.
She understand that? Not from here, you're going on, you know. 1:30 on that day. Wait. If I have one, but give me that, give me that. Swear one. Carlos Pedron.
Mr. Boudreaux? It's cause number CR 21-336, State of Texas versus Carlos David Padron. Motion to adjudicate.
That's correct, Judge. We're gonna set Mr. Pedron for plea at this time at a 9 a.m. plea. I don't think it has to be as far off. It's October, but that date's fine as well.
We do September 30th.
Yes.
All right, court says Mr. Padron to enter his plea September 30th. 9 a.m.
Yeah. Sure.
It's just, who says, how did we know he needed it?
This is the question.
Sent Holly a message. All right, court calls number CR 23-62, State of Texas versus Yvonne Molina Hernandez. Court finds that Mr. Molina Hernandez was given notice to be in court today on the state's motion to adjudicate. Court has arranged for a Spanish interpreter to be present. Mr. Molina Hernandez has failed to appear. Court hereby finds his bond to be insufficient and will issue a warrant for his arrest. And the court is releasing the court appointed and arranged interpreter at this time.
Good morning, Judge.
And it did not appear. So I gave him some time. I tried to send you a message. So he did not appear.
Oh, I'm sorry. I lost your audio. That was so strange.
Okay, can you hear me now?
Yes, sir.
Yeah, so the defendant failed to appear on call his name.
Okay, well, no problem. I'll see you next time then.
Thank you.
Thanks. Bye.
Just really to see that.
You can be seated. This is cause number CR 25-21, State of Texas versus Douglas Heath English. Court finds that Mr. English was previously found to be indigent, had appointed attorney at his request. Court appointing the Honorable Jonathan Manning as counsel. Court finds that we've had several hearings and that Mr. English has been placed on the jury selection docket for September 8th. Court finding also that the defendant having communicated to the court regarding a request to terminate court-appointed attorney. Mr. Manning, I've reviewed your motion that I believe you filed at the request of Mr. English to terminate your counsel. Is that correct?
Judge, I apologize. I don't believe I filed a motion.
Did you not?
This was just set at Mr. English's request. I have no objection to his motion withdrawing. I do have an objection to some of the facts within the motion, and if we'd like to, we can take that up at a later time. But I have no objection to his motion asking him to withdraw.
Mr. English, do you want to hire an attorney to represent you in this case?
I don't have any money. I've lost everything I've had in the last 4 months. That's why.
So the answer is no.
Yes, sir.
Okay. And so you're wanting to terminate Mr. Manning, who the court appointed to be your attorney because you can't afford one. So why are you wanting to terminate Mr. Manning's representation of you?
After I was arrested, put in jail, there were days that he came, I only got to see him for 2 minutes. And he would state, I will come by and talk to you tomorrow. Tomorrow came 60 days later for 2 minutes before I stood in front of the camera, said the same thing. 30 days later, I see him.
You're not in jail.
Nothing. My wife turned my phone off while I was locked up. I've lost my truck. I had to move back in with mom and dad.
Do your parents have a phone?
Yes, sir. But my mom is back and forth with my 2 special needs grandkids.
But you haven't asked if you can use their attorney to set up an appointment to address your
Yes,
issues?
sir. That was,
So once you got out of jail, you just made no effort on your own to contact your attorney?
I wrote this letter.
Okay, you wrote this to the court.
Right.
I'm asking you a different question. Once you got out of jail, did you do anything
No,
to
sir.
try? Hang on,
Because
hang on. You got to listen to me because you don't even know what I'm going to say.
Yes, sir.
Okay? So listen, we're thinking about what you want to say as I'm talking and listen to what I'm asking you.
Yes, sir.
Have you done anything since being released from custody to make any kind of arrangements, to speak with Mr. Manning, to call his office, to make an appointment, to have someone drop you off up there so you can try to see him? Have you done anything of that
No,
nature?
sir.
Why not, Mr. English? That makes no
Because-
sense. That makes no sense to me if you're frustrated that Mr. Manning's not coming to see you, and then when you get out, you do what you're alleging he's done. You don't go to see him.
On Friday, before I got out, I got a letter in from the jail. They brought it to me saying that I would be here today to terminate counsel. So that's,
Well, what did you say in your letter?
that.
Let me read it to you. I want to fire my attorney, Mr. Manning. I do not believe he is doing his job or has my best interest in mind. He refuses calls or answer emails, thus keeping me in the 2 to 5 minutes just before court each of those days. That's not ample enough time to go over or discuss the case. Please grant my request for a new attorney. Thank you for your time and consideration. And that was dated August 4th.
Yes, sir.
So since being out of custody, how did you get out of custody?
My parents bonded me out.
So your parents bonded you out. So your parents are willing to give a bondsman money to get you, willing to let you borrow a phone, borrow a car, or assist you in contacting your attorney?
They only had to give very little to the bondsman to reinstate my bond.
Understand?
And I can't drive. My mom's busy, and I understand what you're saying. I do. I should have, even though I wrote this and it took 8 days to leave the jail to get to here. He came and saw me after this was written. We talked nearly an hour, almost 2 hours. I sit in the room, and then my dad has an episode. They get me out so I can take up his slack, and I haven't. I've been scatterbrained because of that.
You're still in the dark on your criminal case.
No, I pretty much know what's going on. The fact that you tell me you're going to come speak to me, and we'll go over this and we'll go over that, and then I don't see you for 60 days, but that's kind of keeping me in the dark, sir.
How's it keeping you in the dark?
Because I don't know what he's found out, what's going on, if anything has changed.
But you, at the same time, you've not called him to ask him if anything's changed or that he's found out anything new from the last time we talked. Isn't that right?
Yes, sir.
You've not gone by his office.
No, sir.
You've not asked anyone to call on your behalf.
No, sir.
You've not sent an email to Mr. Manning.
No, sir. My phone doesn't.
So, Mr. English, if I were to grant your request right at this very moment and appointed you another attorney, if you're not going to take the effort to go and meet with the attorney and ask questions and contact them, then what benefit would that do for you if you're not going to do your part?
We did speak before I got arrested. Went to his office like he told me I was early. We sat and we spoke, and didn't get to speak again because I got rearrested and been in the county. And I've written letters. I have tried to call. I did send an email from the county. Nothing. I didn't get a return letter. The email said on the kiosk has not been answered.
Mr. Manning, would you like to respond?
I would, Judge. I think it would help elucidate kind of what's going on here to clarify the record that I was originally appointed on CR 2521, which is the case before this court. And that case had a date of offense from January of 2020. I'm sorry, from February 21st of 2024. And that was indicted on January 17th of 2025. Once I was originally appointed to that case, as Mr. English said, we had a discovery meeting at my office that February 18th of 2025, where he and I discussed at length defense's impossible course of action for the assault that was filed here in this court. At that time, from my understanding, my client's intent was to take that to trial, so we prepared in that fashion. Subsequent to that, on April 14th of 2025, I'm sorry, April 12th is the date of the indictment. Mr. English was picked up on a DWI, 3583 downstairs. He was arrested on that offense and not indicted until July 24th of 2025. I'll elicit testimony here in a moment, but on the bond revocation, the original case. And so it did no good for us to get a bond on the delayed indictment of SC 2583. As Mr. English discovery meeting on August 15th, which is less than a month after I received the indictment and discovery for the FC 2583 case, we had a discovery meeting where I was able to go over the allegations in depth and as well as the discovery for the new charge. As a point of clarification, if you look at the letter that Mr. English sent, the last date he lists that I was unable to come see him the next day was July 10th of 2025. As I said before, if the court takes judicial notice of the case file for FC 2583, the case wasn't indicted until July 24th. And I explained to Mr. English again and again that I didn't have the new discovery to go over with him at that point in time to discuss what his options were on the new case and how that would affect the old case. We'd already prepared the old case, but we didn't have the new discovery to discuss that. So if the court would like, I can call my client to establish some of those facts, but I wanted to clarify that we're dealing with two separate issues here, two separate cases, and the timeline for the first case was muddled by Mr. English's subsequent arrest and detention on the new offense.
All right, Mr. English, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Sir. All right, court is going to allow the defendant to be called for the very limited purpose of discussing the circumstances surrounding his letter to the court to terminate court-appointed counsel. Go ahead, Mr. Manning. We'll just do this. Mr. English, come on up here. What's your step when you get in? Raise it up. Thank you, sir. Go ahead, Mr. Manning.
Thank you, Judge. Mr. English, you heard my summation earlier. Isn't it true that on CR 2520, I'm sorry, before we begin, let me advise you that you are under oath. Let me advise you that also during the course of this, to avoid saying anything regarding the facts of your case and or attorney-client negotiations or discussions that we've had that may impair your ability to try these cases in the future. You understand that?
Not really, but
what I'm telling you is you need to be very careful how you answer the questions to not reveal any of our strategy for either the CR 25 case, CR 25 2021, which is the assault case, or the SC 2583 case, which is the DWI case. You understand that?
yes, sir.
Okay. When I was originally pointed to your original case, the CR 2521, that was appointed here in court. Is that correct?
Yes, sir.
Okay, and I gave you the all the ways to contact me, and I emphasized that email was the best way to contact me. And I gave you my card. Is that correct?
Yes, sir.
Okay, and you in fact were able to use that information to contact me and set up an appointment for February 18th of 2025 to go over discovery in your case. Is that correct?
To the best of my knowledge.
Okay, and you came to my office and we sat down and we discussed CR 2521 in length and discussed potential defenses, discussed mitigation, and discussed what you would like to do with that case. Is that correct?
Yes, sir.
And at that point in time, you made it clear that you were requesting to have a trial on CR 2521. Is that correct?
I don't recall.
Okay. Would it be fair to say that you at that point in time were were set in that you were not guilty of that offense.
Yes, sir.
And I explained to you that the only way to proceed with a plea of not guilty based off of what the state was alleging was to go forward and have a jury or the judge hear your case and make a decision on those facts. Is that correct?
Yes, sir.
Okay. And so we began preparing for trial in February of 2025 on the case that was indicted in January of 2025. Is that correct?
Yes.
And that would have been actually almost to the day 1 month from when you were indicted on that case and less than 1 month from when I was appointed on that case. Is that correct?
Yes, sir.
And we continued through our settings with you reporting here on bond each and every setting until April 12th or 14th of 2025. Is that correct?
Yes, sir.
Okay. And the next thing I know, have been appointed to a new offense. And the first I hear of it is that you have a new offense for DWI. Is that correct?
Yes, sir.
Okay. And when I came to visit you on the new appointment, I explained to you the consequences of the bond revocation and how that would make bonding out more difficult and how the judge would be less inclined to allow you any future bond reductions based on you picking up a new offense while on bond. Was that correct?
Yes, sir.
Okay. And you explained to me the difficulties that were going on at home. You explained to me the financial difficulties that were happening. And you explained to me the need to get out on bond to help your family. Is that correct?
Yes, sir.
And I spoke to and coordinated with your mother, Miss English, to attempt to see if there was any way to negotiate a bond for both, not just the original bond revocation on CR 2521, but additionally on FC 2583. Is that correct?
I don't know.
Let me ask this. What's your mom's name?
Linda?
Okay. And are the last 4 digits of her phone number 6981?
Yes.
Okay. And did you speak to your mother about my representation?
Yes.
Okay. And did she tell you that I spoke to her not once, not twice, but multiple times about your case?
She said you spoke to, I know of 2 times.
Okay. And we were unable to get you a bond at that time on the new case. And so I explained to you that your only option at that time was for us to wait and see what the state did with your new offense. Is that correct?
Yes.
Okay. And unfortunately, the state did not timely indict your case until July 24th of 2025. Is that correct?
To the best of my knowledge.
And during one of those settings, I believe it was the July 10th setting, we had a conversation about if the state did not timely file the case, filing for a PR bond or personal recognizance bond in FC 2583 due to delay on behalf of the state. Is that correct?
Yes, sir.
And at that point in time, you explained to me that even if we got a PR bond in FC 2583, that would not help you because the bond was too high in CR 2521, and you were unable to make both bonds at that point in time. Is that correct?
I believe that I explained that if I got the PR bond, that the other bail bondsman would reinstate for $150.
Okay. But at that point in time, you couldn't make the new bond on CR 2521. Is that correct?
I could have, but I still had the DWI bond that I was just waiting to figure out on the bond reduction if it was going to be reduced. And like you explained, wait for 90 days, PR bond, she could reinstate.
And isn't it true that after you were indicted on July 24th, 2025, I came prior to receiving this letter and being served this letter by the court, I came to the jail and visited you on August 15th, 2025 to discuss the recently released discovery for the new DWI case.
Yes, sir.
Okay.
After the letter had already been mailed. Yes, sir.
Okay. But before I had received it, is that correct? You said that it took 8 days to get out of the jail?
Yes, sir.
Okay.
They only send mail out on Tuesdays.
Okay. And it looks like it was dated August 4th, 2025. Is that correct?
Yes, sir.
Okay. And I came and visited you on August 15th. Is that correct?
Yes, sir.
So in both cases, you would agree that I came and went over the entirety of the case file for both indictments in less than a month after those items were made available to me. Is that correct?
It would appear so, yes, sir.
And we did that both at my office where you set up an appointment and we communicated there, and at the jail where you were subsequently in custody for a new offense. Is that correct?
Yes, sir. The letter was written after I had been incarcerated and was wanting to know what was going on. I knew up to a point what was going on. And then when I got in there, you're behind walls with no windows, doors. You don't know what time it is. You don't know what's going on. So
And is it, just one final question, Mr. English, isn't it true that on the dates alleged in your letter, April 17th, June 12th, and July 10th, that I told you that there was nothing more to discuss at this time until the DA's office filed the new case, because we had already gone over the discovery in CR 2521 and we were waiting for the discovery in the DWI case. Is that correct?
yes. And then when I signed and got my yellow piece of paper is when you stated, I will see you tomorrow and we'll talk.
Your Honor, at that time, I have no further questions.
State, any questions? All right, Mr. English, you got anything else that you want to say on this matter?
Sir.
No? All right, you can step down. Any further, Mr. Manning?
Nothing further, Judge.
All right, Mr. English, are you still asking the court to remove Mr. Manning as your attorney?
Depends on if he's going to have any ill will towards me.
Mr. Manning, do you want to address that?
Judge, I'm a professional. I can put these things aside. What I can't abide, though, is a twisting of the facts or misstatement of the facts to suit a particular narrative, Judge. I've done my best work to get Mr. English an offer on two cases that are 25 to life, and because of the way that the cases came out, we weren't able to take that offer. So now we're set for trial up here as number 4 case, and set for trial, or potentially going to be set for trial downstairs. And so, no, Judge, there will not be any ill will, but because of Mr. English's actions, because of having to deal with this, I'm afraid that some of his options the doors may have been closed on those options.
Options from the state?
Yes, Judge.
Mr. English, you're set for trial a week after next on Monday, and there's a good chance that you'll be the number 1 case for trial. You want to represent yourself?
Yes, sir.
You want to hire an attorney?
Try.
You're going to try to hire an attorney?
I guess I have no choice.
Well, I mean, you have a choice.
I'll see what I can do. I'll try to hire somebody. I didn't know it was going to be that fast. The last I heard it, when I got into the top 10, I would be notified. Then now it's set for a week or two now.
I can't hear you.
The last that I heard it, I would be notified when I was in the top 10, and I didn't even know I was in the top 10. Now it's set for a week and a half.
You know, if I may just ask the court to judicial notice of when Mr. English was set in the top 10. I believe this was his first setting in the top 10, and that notice was sent, I believe, after the letter and communication were sent by Mr. English.
All right, Mr. English, I'm going to deny your request to remove Mr. Manning. I find that the allegations that you have alleged in your letter to the court to not be true based on your testimony and the information provided by Mr. Manning. So you are set for trial week after next. If you want to hire an attorney, you have that right. You can go do so. Otherwise, I do not find grounds for Mr. Manning to be removed. I find that Mr. Manning, based on his statement, will not hold any, as your words say, ill will towards you. However, I would suggest that you not make statements and file them with the court that would result in the court having hearing if they are not true. That only goes to your detriment. And I wouldn't blame Mr. Manning if he filed a motion to remove because he doesn't trust that you're going to be able to abide by the professional attorney-client relationship. So if you want to hire an attorney, you may do so. And I'll tell you, if you're number one for trial, I'm not going to grant a continuance because you hire an attorney. The attorney will need to be ready to go for trial when your case is called for trial.
Yes, sir.
All right, if there's nothing further than you're excused. We'll see you back on September 8th.
I believe that concludes my business, maybe excuse.
Is that all you have, Mr. Manning? Let's see.
Judge, wait, I'm sorry, Mr. Autry, I was unable to get a hold of him. And I attempted to reach out, get a couple different numbers, upon looking at the file, he was granted the PR bonds. And so the information I have is what was given before it was released.
All right, court finds that Billy Ray Autry's name has been called 9 a.m. with no response. The court will have his name called loudly distinctly 3 times in the courthouse. Upon failure to appear, the court will issue judgment nisi and habeas corpus. Court takes judicial notice of the notice of setting, which contains the correct address that was placed on his personal bond as the address that we sent notice to.
Thank you, Judge.
Mr. Schmidt, are you ready? Mr. Pryor?
Yes.
Mr. Pryor, come on up. We're going to stand in recess for just a few moments for the court reporter, and then we'll proceed. All right, court is on record in cause number CR 15-322, State of Texas versus Keith Pryor. Court finds that court previously accepted Mr. Pryor's pleas of true to certain counts alleged in the state's motion to adjudicate. Court took that plea of true under advisement and set sentencing hearing today. Mr. Schmidt, are you, Mr. Pryor, ready?
Yes, sir.
Hartwell, you ready?
Yes, sir.
All right. Mr. Hartwell, you may proceed.
Thank you, Your Honor. I have a couple of certified copies of judgments. How would Your Honor like those marked as MTA 1, 2, 3, and so on?
However, as long as it's not states one, because I believe that we already probably have a states one from the original plea.
Yes, sir. And Your Honor, state has states MTA 1, MTA 2, MTA 3, which are actually already in the court's file and are in this case as a judgment, conditions of probation, and the stipulation of evidence.
As to 1, 2, and 3, we have no objection.
All right, court finding there is no objection. The court admits states MTA 1, 2, and 3.
Your Honor, state also has MTA 4, which is a judgment out of certified copy of a judgment out of Polk County, Florida, dated October 25th of 2024.
And Judge, to that exhibit, we would object as to relevance. Also, we'd object as to that document is outside the scope of the term of community supervision that this defendant was subjected to.
And Your Honor, it goes to punishment. And basically the argument that while it's outside the term of probation, goes to show that Mr. Pryor has not in fact performed.
Your response?
Renew my objection. It's not relevant to these proceedings as the term of all of the violations that are before this court are during the term of his community supervision. Furthermore, even though that document is I believe it's under seal, it's not authenticated as to this defendant. And I don't believe the state is prepared to do so with any witnesses showing them the document is indeed Keith Pryor.
Court overrules the objection as to relevance. You have a response as to authentication?
Your Honor, if we were going to show that it was a prior for enhancement purposes, of course we have to defend it, that this is a certified copy. And as the court recalls, we've been waiting, we had to wait for however many months to get Mr. Pryor from Polk County on this case. He was in Polk County custody the entire time we were waiting for this MTA to go through because of this judgment.
Judge, I don't think there's been any evidence presented on the record to authenticate that. So I think lack of authentication still applies. And that if the state wanted to attach that judgment to Mr. Pryor, they'd have to provide the court with some evidence that that indeed is this Keith Pryor was before the court today. And I believe they're prepared to act on that.
All right, the court sustains the objection as to authentication on state's MTA 4. If you have other evidence to authenticate it, then you're welcome to present that to the court.
And Judge, I know the state has 5 and 6, we would lodge the same objections to those documents as to relevance and lack of authentication.
Well, he hasn't offered those yet, so I don't.
Understood.
Well, Your Honor, states 5 is a prior judgment which happened prior to this case. Again, for punishment purposes, state believes that the court should be considering Mr. Pryor's entire history as it would do in any sentencing hearing. This was an unadjudicated offense, which state is asking the court to adjudicate and sentence. These are matters that this court should be able to consider in sentencing. Again, these are certified copies and therefore are self-authenticating.
And Judge, I would renew my objection as to, although they do appear to be documents under seal, they are not, the state is not prepared, nor can they prove that those documents relate to Keith Pryor. So without that evidence, I object to relevance as well. I believe states 5 has no fingerprints on it. State 6 may have fingerprints. But either way, we object to authentication on both of those documents as it pertains to Mr. Pryor.
And Your Honor, that should go to weight, not admissibility.
Are either one of the judgments in states exhibit state's motion to adjudicate exhibit 5 and 6? Are those related to the priors alleged in the indictment?
Your Honor, I'd like to have a moment to.
There's a judgment of GB.
And counsel, I'm looking at the indictment here, and I don't see any priors alleged. I thought due to the enhanced punishment range there would be, but apparently maybe the legal assertion is that it was based on the amount of the controlled substance that would have.
Yes, Your Honor. However, there is in the PSI by Mr. Pryor's own admission during the PSI, the prison time and state jail time in Florida.
Tell me where you're looking at in the PSI.
Your Honor, on page 2, adult criminal record, yes. Status at time of offense, previous criminal history, county and state of Florida, community supervision, Florida, parole mandatory supervision, Florida, age at first conviction 21.
So that's on page 2.
Yes, Your Honor, at least the pages that I'm looking at.
What's the, sorry, and what I'm looking at is the pre-sentence investigation report. My page 2 begins with school work history.
I'm sorry, Your Honor, mine starts with custodial information, then moves to criminal history. Maybe approach.
That's all right. I'll figure it out. Okay, I'm on the page that you're on now. All right, so what's your argument?
That, Your Honor, based on the admissions of the previous criminal history in Florida, that Mr. Pryor has admitted in the PSI that he does have prior criminal history in Florida.
See a reference to the information you're referring to, and it says CCCH, which stands for computerized criminal history. And in reviewing that, can you point the court to any information on the computerized criminal history that relates to the judgment you're referring to?
Your Honor, if we're looking at the same document, the computerized criminal history search only relates to Texas cases because it would be limited to the DPS records in Texas. What I'm referring to is the very top of the page says source of information D. It would have been part of the actual interview.
But on the top of page 2 of the computerized criminal history search, does it not indicate that he was he arrested in Hollywood, Florida?
Yes, Your Honor, I do see the Hollywood, Florida arresting agency. Your Honor, I believe that is actually the home address because it says arresting agency Canton PD.
That would be the address of who?
Of Mr. Pryor.
So there's nothing in the computerized criminal history. So on page 2 of the PSI, you're indicating that where it says prison, yes, and it says CCH. Below that, it says status at time of arrest, previous criminal history, Florida, community supervision, Florida, parole mandatory supervision, Florida. And you're saying that information was derived from Mr. Pryor?
Your Honor, I believe that it would have been based off of the PSI being an interview with him.
Judge, I don't know that to be the case.
All right, court is going to deny the defendants or overrule the defendants' objections as to states MTA. You say it's 5 and 6,
Yes, Your Honor.
or will admit those into evidence.
Okay.
And Your Honor, from there, state only has argument,
No witnesses.
no witnesses. Your Honor.
All right. Mr. Schmidt,
Yes, sir, I'd call, Keith Pryor.
Mr. Pryor, coming forward. Before you enter, I'm gonna place you on those. So do you swear that the testimony you give to the court today will be the truth, your whole truth, and nothing but the truth, so I can say. What's your step? How you doing? See, your testimony to speak up mildly and clearly, so we have to say.
Okay.
Allow the attorneys to finish the questions before you give an answer. You start talking at the same time, that makes it very difficult. We're over here, type down, over what you're saying. If any of the attorneys stand up to object, that they say objection while you're testifying, just stop. That's fine. The court will rule on that, and I'll let you know how to proceed. Mr. Schmidt.
Thank you, Judge. Mr. Pryor, state your full name for the record.
Keith Cornelius Pryor.
Mr. Pryor, you've been in custody in Van Zandt County on the state's motion to adjudicate your probation since roughly January of this year, is that correct? Or do you
Yes,
know
sir.
the date?
No, sir.
So, March 11th, you got into Van Zandt County.
Yeah, I think so.
And you're actually arrested on Van Zandt County warrant in Florida, is that correct?
Yes, sir.
Is that where you're originally from?
Yes.
You have family in Florida?
Yes, sir.
Now, when we were in court last, we sat here before the judge and addressed the state's motion to adjudicate, and we looked at all of the violations that they alleged in that motion. You recall that?
Yes.
And ultimately, you pled true to the court on the counts that related to either positive urinalysis or admissions of some drug use. You recall that?
Yes, sir.
All of the other counts were abandoned.
Yes, sir.
Now, when you pled true, after looking at the motion to adjudicate, it appears that the counts that you admitted to the court were true all occurred on two separate dates. One of those dates was December 14th, 2023. Do you recall that?
Yes.
What is the significance of that date?
My mother had passed away, and I'm the only child from my brothers, from my dad, kids. I'm the only child from my mom, and it hit me real hard. And I messed up. I can admit that I did mess up, but it was a hard time for me, and I did, did something I wasn't supposed to do, and that's why I admitted true to the allegations.
Now, you had another bad day within this term of probation, and that was February 9th, 2024. What is the significance of that day?
That's my mom's birthday, close to my mom's birthday, and I just had a bad trip. I messed up. I can admit that. I was wrong. I apologize, Judge. I know I wasn't supposed to do what I did, but being as the only child, that's the only woman that I know. And
So, Mr. Pryor, what you're telling the court, if I may, is that your coping mechanisms for this sort of stress are inappropriate. Is that correct?
yes, sir.
And let's get on to the other issues. Did you complete your community service?
Yes, sir. I paid $9,860.
And did you report as a worker?
Yes, I reported, never missed a report date. I did everything I was supposed to do except for one class, and I took the class, but my probation officer in Canton told me that she wasn't accepting it on Zoom.
So let me stop you. I think you're referring to count 9, which is alleged that you failed to complete a drug education program within 90 days. Is that correct?
Yes, sir.
Now, I believe we pled true to that to the judge when we were here last.
Okay.
Right?
Yes, sir.
Now, your explanation was that you were attempting to complete that class
Yes.
at the time that this was filed, or prior to the expiration of your
Prior
term?
to the expiration.
And what efforts did you engage in to try to get that done?
I paid for the class, and I was attending the class,
But when I contacted Ms. Danielle Griffin, she specifically told me and my wife that she wasn't taking it on Zoom, that she wanted me to take it in person, but come to find out now that they are accepting it in Zoom.
Okay, so there was some miscommunication about whether or not that class qualified to meet the standard.
Correct. Correct.
But you had made efforts.
Yes, I have proof that I paid for the class, everything.
Okay. And so going forward, during the term of your community supervision, there's no allegations that you committed any new offenses, is that correct?
Yes, sir.
And as far as you know, other than the 2 bad days that you had during your probation, the state hasn't alleged any other violations other than that.
Yes, sir.
And they withdrew the other violations because your money's paid, your community service is done, et cetera.
Yes, sir.
Now, while you've been in custody waiting for us to resolve this motion to adjudicate, have you been making efforts to improve yourself?
Yes, sir. I've been attending Alcohol Anonymous and Narcotics Anonymous. I've been doing that for the past 5 weeks, and I've been taking courses on the tablet, the in-school courses for reentry to society, freedom for pain, stress.
Both of those. So you took a course called Mental Freedom, Freedom from Pain. What is that course about?
Well, it helps you learn how to maintain your stress ability when times get hard.
And you also took a class called The Basics of Managing Stress. Is that correct?
Yes, sir.
And did you complete that course?
Yes, sir.
And what did that one teach you?
It taught me just when life get hard, just you can handle it. Everything, sometimes when you go through stuff, that's for God to make you a better person.
Did you take a class called Health and Wellness Coaching?
Yes, sir.
What is that one?
That's about your health and things that you need to do to keep yourself healthy, and things that not to do so you don't like mess up because you're getting old. I'm getting older.
What about retaining higher education for success?
Oh, that right there, that teaches to learn more programs and different trades on what you want to do in life, or you manage your life when you get back into society.
I think you took a course called The Beginner's Guide to Stock Market Dividend Investing. Is that correct?
Yes, sir.
What is that?
That helps you to learn about stocks and bonds. I just wanted to try some, to help myself do something different in life.
And Reentry 101, is that another class?
Yes, sir. That's for reentry from when you come from being incarcerated. It helps you to give you steps on how to on what to do right, and it just give you a lot of options on help you guide your life to reentry to society.
And on all of those classes that you took and completed, did you receive a certificate of course completion?
Yes, sir.
Were you able to print those out though to this point?
Yes, sir.
And did you print those out from the jail, is that correct?
The sergeant printed them out for me.
Sergeant printed them out?
Yes, Sergeant Lockhead.
I'd like to admit, which are the certificate of course completions for various classes that you discussed.
No objection.
There being no objection, defendants exhibits 1 through 7 are admitted.
Mr. Pryor, how old are you?
43. I just turned 43 August 24th.
Turned 43 in jail, is that correct?
Yes, sir.
How many children do you have?
3 daughters,
3 daughters.
23, 11, and 8.
Say that again, what's their ages?
23, 11, and 8.
The youngsters live.
Well, right now, they reside in Florida, but my 23-year-old and my 11-year-old supposed to come stay with me, but Bobby being incarcerated, they've been down there with their grandmother, so they really waiting on me to get out. So, cause I'm the sole protector, I'm the provider. So,
Are you married?
engaged,
And is the woman what's her name?
Bonnie Bowens.
And is she waiting on you to get out as well?
Yes, sir.
And do you anticipate, once you're released, and I guess what I'm trying to ask you is that you turned 43 in jail. Is that a life for your children?
No, sir.
Is it a good thing for those kids to grow up with their dad locked away?
No, sir.
And we testified about some of the steps you've taken while you've been sitting in jail to try to better yourself. Are you ready to take all those skills that you've learned through being in the system and put that life behind you?
Yes, sir.
And I guess the biggest concern for most people is that, that you just keep cycling through. And at this stage in your life, are you tired of it?
Yes, sir. Yes, sir. Very tired.
Ready to have a real life,
Yes, sir.
free of drugs and alcohol?
Yes, sir.
Now, if you are released or when you're released, are you prepared to continue to use the skills that you've learned to stay away from drugs and alcohol?
Yes, sir.
Obviously, those anniversaries of your mother's passing and her birthday, they ain't going to go away as long as you're alive.
Yes, sir.
And you understand that those are triggers for you.
Yes, sir.
Stress and depression.
Yes, sir.
Do you think that you're prepared to manage that without resorting to drugs and alcohol?
Yes, sir. I have a strong support system, sir. I have a very strong support system that love me.
In addition to that, do you intend to continue with NA and AA once you're a free man?
Yes, sir.
Do you believe that helps you kind of stay on focus?
Yes, sir.
So coming here today in our prior trip to this courthouse, one of the things that you and I discussed, and one of the things that you told me was that you understand that you have to take responsibility for your mistakes.
Yes.
And you testified to the judge as to, you understand that you shouldn't have engaged in the violations, the drug violations.
Yes, sir.
And because of that, and because of your desire to take responsibility of your mistakes, we didn't have a contested hearing and make the state jump through all the hoops to prove those violations, correct?
Yes, sir.
And you pled true because in fact they were true.
Yes, sir.
Now at this stage, you're here for your sentencing, and the judge has several options at this point of what the court can do as far as your sentencing is concerned. One of those is he can deny the state's motion and terminate your community supervision. You understand that?
Yes, sir.
Obviously, that would be your first request of this court. Is that right?
Yes, sir.
And you're asking this judge to do that and allow you to go be with your family.
Yes, sir.
Now, if the court determines that isn't an option, that it chooses to exercise, another option is to sentence you to a term of confinement up to 10 years and to suspend that sentence and let you get another shot at probation.
Yes, sir.
Would that be your second request of the court in the alternative?
Yes, sir.
Now, considering that you had those two violations on 2 days in the whole term of your probation, we know what the problem is, don't we?
Yes, sir.
And what is that?
My triggers, my mom.
Drugs and alcohol.
Yes, sir.
And so if the judge were to accept that option and sentence you in that fashion, you understand that all of the conditions that you were previously under during probation would apply again.
Yes, sir.
No drugs, no alcohol, no criminal offenses, etc.
Yes, sir.
And if the court determines that that's what the court wants to do, are you prepared to abide by those conditions?
Yes, sir. Yes, sir.
I'll pass the minutes.
Very well.
Thank you, Your Honor. Mr. Pryor, this motion was filed in March of 2024, but you came into custody in Van Zandt County in March of 2025. What happened in that year between the motion being filed and you coming into custody here?
March what?
Between March of 2024 and March of 2025 when you came into our custody?
I had some old charges for driving without a license. And then I had caught a case and
Hey, Judge, I'm sorry, I was asleep at the wheel. I'd object to relevance.
Overruled. Answer the question.
I was in Lakeland, Florida, and I sat in the county jail for 6 months because I had a paraphernalia charge, a driver without a license, and a possession of a marijuana charge.
And was one of those charges a felony?
Yes, sir.
During your interview, during your pre-sentence investigation, you told the probation officer that for this event, and that interview for the record took place on June 17th of 2025, that you had a couple of friends that asked you to go for a drive with them and you weren't doing anything, so you said, okay, is that correct?
Yes, sir.
And that when you were pulled over, you were asleep in the back seat?
Yes, sir.
And that you didn't know anything about this, the drugs, the cocaine?
Yes, sir.
So then why plead guilty to it if you knew nothing about it?
Well, the other person that was on my case pled guilty, and my lawyer, he kind of talked me into, he was like, that's the best that's going to happen for me. So that's the best deal to take. So I took it.
So you still refuse to accept responsibility for the nearly kilo of cocaine?
It wasn't my kilo of cocaine anyway. It wasn't mine. It was 3 people in that car. I was in the back seat.
Do you know where the cocaine was in the car?
No. I had no knowledge of it.
Nothing further, Your Honor.
Mr. Schmidt.
Just briefly, Judge. On the underlying charge, did your lawyer at the time explain to you the legal definition of possession?
No.
Did he tell you it was actual care, custody, control of the contraband?
No, he didn't. What he told me was that he basically was just telling me that this is the best offer to take. He really didn't explain anything. If I'd have known like all the stipulations, like exactly where as far as I didn't know that.
Well, Mr. Pryor, you understand that, you know, there can be a difference between legal guilt
Yeah.
and what you believe. In other words, you know, if you're in a car with cocaine, you can be legally guilty and still believe that you shouldn't be found guilty.
Correct.
And so under the circumstances and the evidence that existed at that time and with consultation with your attorney at that time, did you determine that legally it was the right thing for you to do?
Yes, sir.
To accept responsibility,
Yes, sir.
part in it, and then to submit to a term of probation?
Yes, sir.
I'll pass it.
Just briefly, Your Honor. Mr. Pryor, when you were put on probation, were you told that a single violation would result in incarceration, could result in incarceration not less than 15 years and not to exceed life? Nobody
No.
ever told you that?
No.
Nobody at probation ever told you? Not the judge? Nobody told you that?
Not can I recall. Not can I recall. This happened 10 years ago. So I can't really recall what was said, to be honest with you. But I know that I had a misinterpretation of what can happen to me if I get violated. And Mr. Smith could tell you himself. I was like, huh? What do you mean? So to be honest with you, I can't recall.
Nothing further, Your Honor.
Mr. Schmidt, anything further?
Mr. Pryor, you understand the circumstances now, correct?
Yes, sir. Fully understand.
Pass.
Nothing further, Your Honor. Thank you.
You may step in.
Yeah, you can go.
Schmidt, any additional witnesses or evidence?
We rest, Judge.
Any rebuttal?
Nothing from the state, Your Honor. State rests.
You wish to close? Go ahead.
Thank you, Your Honor. Your Honor, I would point you to the evidence in the case that this is 993.06 grams of cocaine. Mr. Pryor pled guilty to the offense of manufacturing delivery, so possession with intent to manufacture or deliver. This is an enhanced punishment range. 15 years is the minimum, not to exceed 99 years of life. Mr. Pryor has a criminal history in Florida, and as the evidence shows the court, he continues to engage in criminal conduct outside of probation. Your Honor, including more felony charges. Your Honor, state believes that Mr. Pryor has not reformed, that his conduct shows that while he may be able to keep out of trouble while on probation, when he's not on probation, Your Honor, he is going to continue committing felonies and drug offenses. Your Honor, state does recognize that Mr. Pryor was largely successful on probation. 993 grams, Your Honor, typically I'd be asking for a sentence of not less than 40 years. However, because Mr. Pryor was largely successful, I'm asking the court to revoke his probation and assess a punishment in the range of 15 to 20 years. I believe that that is appropriate given all the circumstances.
Thank you, Mr. Hartwell. Mr. Schmidt.
Judge, time of sentencing, the state was comfortable not sentencing Mr. Pryor to a term of imprisonment, despite the facts of the case. Obviously, if they weren't comfortable with that, we wouldn't be here. The evidence that was presented to the court and the pleas of true in the state's motion basically amount to, in a period of 5 years, Mr. Pryor having two bad days. And that's the term of his probation. Now, as the court is aware, there have been innumerable occasions where an individual with far greater violations has been given another opportunity to succeed. Under the circumstances, we've got all of the fines and fees are paid up, community services completed. We have 2 days where he had some drug usage, and he explained that obviously that was a coping mechanism based on the significance of those dates. Mr. Pryor has, rather than sleeping all day in the jail, has taken that time to try to better himself as we go forward. Under the circumstances and based on his testimony, he understands that those violations are indeed violations, and there are consequences for violations, Judge. What the request that the state's making is a harsh penalty, and in my estimation would not do justice to the community or to Mr. Pryor. So we would ask that firstly the court deny the state's motion to adjudicate and discharge Mr. Pryor and let him get on about his business. But in the alternative, we'd ask that the court sentence him to a term of confinement and suspend that and allow him another opportunity to prove to this court that indeed he can continue in society without ongoing criminal violations or drug use for that matter, Judge.
Hartwell.
Your Honor, Mr. Pryor knew what he was getting into, pled guilty. Your Honor presided over the guilty plea, and I know that Your Honor makes sure that every defendant who pleads understands what they are pleading to. That is the court's normal course of business. Mr. Pryor knew what he was getting into. And Your Honor, again, when he's not on probation, Mr. Pryor is continuing to engage in drug conduct, felonious conduct. Fool me once, shame on you. Fool me twice, shame on me. Your Honor, at this point, I think that Mr. Pryor should serve the sentence that he signed up for. And since he violated, should be subjected to the 15, the entire punishment range. But the state would recommend that the court take into consideration the largely successful and limit it to 20 years.
Thank you, Mr. Will. All right, court will take under advisement all of the evidence, the testimony that's been provided today. The court's going to stand in recess to consider those things, and I'll return in 20 minutes. It's 11 o'clock, so 11:30, 30 minutes, I'll return.
And Judge, well, we're in recess on Mr. Pryor's case, just so what the calls, Ms. Sampson's still in the hallway, so check him.
Okay. Court's in recess till 11:30. All right, we are back on record in cause number CR 15-322, State of Texas versus Keith Pryor. All right, the court having considered the evidence, court finds that on March 28th, 2019, Mr. Pryor appeared before this court and pled guilty to the first-degree felony offense of delivery of a controlled substance in penalty group 1, greater than 400 grams. Court found that day that that was a first-degree felony offense with a range of punishment of not less than 15 years or more than 99 years or life confinement in the Texas Department of Criminal Justice Institutional Division, and a possible fine not to exceed $250,000. Court finds that on that date, Mr. Pryor pled guilty to that offense. Court considered a plea agreement that was reached between Mr. Pryor and the state of Texas. The court on that date found that it would be in the best interest of the community and in the best interest of Mr. Pryor for a finding of guilt to be deferred, and the court, and following the plea agreement, placed Mr. Pryor on 5 years of community supervision. It was during that period of community supervision that the state filed its motion to adjudicate guilt and alleged 9 separate counts of violations. Court finds that Mr. Pryor, having appeared previously in this court, has pled true to counts 1, 2, 3, 4, 5, 6, 7, and 9. Court finds that Mr. Pryor has violated the terms and conditions of his community supervision. After considering the evidence today, the court finds that it would not be in the best interest of the community to convict Mr. Pryor and to issue a prison sentence that should then be suspended, placing him back in the community. So therefore, the court finds that the evidence is mitigating to Mr. Pryor's benefit. Court finds, however, though, that mitigating evidence does not entitle him to reformation of the legal sentence that he was under at the time that he pled guilty and accepted the plea agreement between him and the state. Court finding that it's important for agreements to be fulfilled as promised. The court, therefore, finding it would no longer be in the best interest of the community for Mr. Pryor to be in it. The court revokes his community supervision, adjudicates his guilt, sentences him to the minimum sentence of 15 years confinement in the Texas Department of Criminal Justice. The court awards Mr. Pryor all credit time that he is entitled to, for which he has been legally incarcerated on this charge prior to sentencing. Mr. Pryor is hereby remanded to the custody of the sheriff's office so he can carry out the terms and conditions of the sentence. I'm going to have you, we don't have a fingerprint today, do we? We don't have a fingerprint today. Just right where you're at, Mr. Pryor, I'm going to have Sergeant Martinez come over here and take a fingerprint. And then Mr. Hartwell, I would direct the state to prepare the judgment of conviction by the court.
Yes, Your Honor.
Is there anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense, Mr. Schmidt?
No, sir.
Well, there is, at this point, because this is an open plea to the court, even Mr. Pryor's appellate rights as it pertains to sentencing are still intact, having not waived that. However, obviously, he has not mentioned to me that he intends to do that. But if that were to become the case, I'm not a qualified appellate attorney under these circumstances. I'd ask the court to grant an oral motion to withdraw to allow him to get appellate counsel in the event he elects to.
once the court signs the judgment of conviction by the court and it's reviewed by counsel, once that's signed by the court, then Mr. Schmidt, you're discharged as counsel. And should Mr. Pryor send in a request or a motion for new trial or request for appointment of appellate counsel to the court, we will so appoint.
Yes, sir. Thank you. No, sir.
Okay. Mr. Schmidt, any updates on Ms. Sampson?
Last I checked, she had one individual at step 5 that she's trying to get a hold of. Apparently, he's on the job site. I'll go check. This morning brought him just so we can address it.
Yeah, let's go ahead and call her. Deputy Heiser, if you'll go ahead and take Mr. Pryor to the back, we're going to bring in another defendant. We're going to have a commitment order for Mr. Pryor for you to take back. Sir. Ms. Sampson, come on up. This is cause number CR 22-227, State of Texas versus Cole Moni Sampson. Ms. Sampson is set today on a motion to adjudicate. Any announcements, Mr. Schmidt?
Yes, sir. Um, 133. Children, business.
Counsel, your approach. All right, Mr. Schmidt, the court is going to set Ms. Sampson for plea to the court on September 16th at 1:30. Ms. Sampson's to report to the Van Zandt County Justice Center to enter her plea that day. The court does note for the record that there are issues of pretrial release, issues of bail that the court will take up on the 16th should Ms. Sampson not enter her plea on that date. So court's just going to take those under advisement at this time and order her back September 16th. Yes. And Ms. Sampson, make sure that you show up on time at 1:30. You were late this morning, 20 minutes, and that 20 minutes has resulted in the concern that I have for you at this time, if you understand what I'm telling you. Okay, we'll see you back on September 16th at 1:30. Go. All right, I believe that concludes the court's morning docket. The court is not issuing any judgments on site at this time for Mr. Autry. Instead, the court finds that he has checked in with the pretrial release department, and his attorney will be filing a waiver of arraignment that'll be approved by the court. And once that is approved and issued a pretrial date, we'll notify the state.
Thank you, Your Honor.
And with regards to Mr. Ivan Molina Hernandez, his name was called at docket time of 9:30, was not present. The court has had his name called loudly distinctly 3 times with no response. The court is going to take a judgment nisi under advisement. We are checking on the address that was provided by the defendant, apparently Ellis County Jail, letting bond out without writing down an address for which the court could send notice. We do have a contact information as far as a phone number. We're going to try to reach out and see if we can get a hold of Mr. Molina, and the court's going to review whether or not service is effective in this case before it issues a NICE. So that'll be under advisement until Friday.
Yes.
All right, that completing the court's morning docket. We will stand in recess until 2 p.m. Mr. Hartwell, Mr. Hernandez, the court has to attend a hearing in Rains County at 1 o'clock. So I'll be traveling back. I believe we'll start no later than 2.
Sounds good. Thank you, sir.
Court's in recess.